Good evening, kids. Earl has another bone to pick with the police again. He wants to try to defend attorneys, I guess. I don't know. But this is pretty dumb. He says you have the right to have a lawyer present during questioning equals not. So there's two rights to an attorney. There's the Miranda right. That attaches as soon as you've been placed into custody, arrested. When you've been arrested. For too dumb for lawyer out there, that means when you've actually been arrested. Probable cause arrested. The thing about the Miranda attorney, though, is it doesn't actually kick in until you ask for an attorney. You have the right to ask for an attorney, but if you don't ask for an attorney, the police don't have to stop talking to you. As soon as you say, I want an attorney, they're supposed to stop talking to you until either you say, no, I'm okay to go ahead and talk to you without an attorney, or until there's an attorney there. But what the attorney can and can't do is they can advise you on what to say or not to say. They can offer up objections and generally just kind of protect you from the more incriminating kinds of questions. But they can't interfere with the police. They can't stand between you and the police. They can't prevent the police from taking your picture or from taking your blood, at least not through physical means. Maybe they can get a court order or whatever, but they can't actually physically interfere with the police investigation. All they can do is advise you. Then there's the Sixth Amendment right to an attorney that attaches. I mean, it's really nitpicky, but that attaches as soon as formal charges have been filed, like as soon as the grand jury indictment comes down or whatever, or your arraignment, etc. Then you have the right to an attorney. Blah blah blah. So you don't always have the right to have a lawyer present. Now, he gives 3 links. This one is to lgbtnation.com. This is about something entirely different that he doesn't discuss in this video, so I'm not going to address it. The 2 he discusses are above the law. It's this one, lawyer arrested for doing her job, and this KTNV article, which is this one right here. Las Vegas attorney claims he was arrested for telling client not to talk with police. Now, I want to point out 2 things. Remember that Earl is trying to say that there is a pattern here. And again, we have the same issue. Number one, this first one is from January of 2015. That's almost 5 years old. And this one right here is from August 31st of 2018. It is more than a year old. So that's your first problem. This one's also from California. This one's from Nevada. That's 2 states out of, there's a freaking bajillion attorneys out there. If it was a huge problem, then you would hear attorneys making a stink out of it. And in fact, Earl says quite correctly that he says, why is this tolerated? Why is that permitted? Why are judges and district attorneys not stepping up and bringing that to a halt? It would be pretty simple. And it would, Earl, which should make you wonder why judges and district attorneys aren't stepping up to halt it. Because it ruins cases for district attorneys. And judges can halt it simply by not convicting the people who are arrested and or the fruit of the poisonous tree on any interrogations done outside of the presence of the attorney. If you have the right to an attorney and the police remove your attorney and then question you without your attorney, then anything you say is probably going to be suppressed. That's the remedy. So if it was an issue, Earl, you retard, then there are actually things in place that will correct it. Now, why is Earl retarded? Well, here are some of the many reasons. Number one, he goes to biased sources. This is a very biased video. This guy's writing a very biased article. Who the F are you, a diehard villain? Who says stuff like this? Blah, 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 right? So this gal is Jamie Tillotson, right? She is a veteran assistant public defender in San Francisco. She's a deputy public defender. And she sued. She sued over this. And she lost. And so she appealed. And she lost the appeal. This is Jamie Tillotson v. City of San Francisco. I'll put a link in the description. Plaintiff appellant Jamie Tillotson. I'm not going to read all of it, but I'm going to read a lot of it. It's only 4 pages, but it'll go fast. Plaintiff appellant Jamie Tillotson, a deputy public defender in San Francisco, appeals district court's grant of summary judgment to the defendant appellees in her suit stemming from her arrest in the San Francisco Hall of Justice. The plaintiff sued officers and the city for unlawful arrest and excessive force, blah, blah, blah. They affirm the dismissal. The summary judgment. They affirm the summary judgment. The key events in this case are disclosed in multiple cell phone videos, and the underlying facts are not materially disputed. The officers encountered in the Hall of Justice 2 men whom they believed to be perpetrators of a sting of San Francisco robberies. They encountered these guys, and they thought they were perpetrators of a string of San Francisco robberies because their appearance and clothing matched that of the suspects depicted in high-resolution images taken from surveillance footage of the most recent burglary. One of the men in the Hall of Justice appeared to be wearing the same distinctive jacket worn by one of the suspects in the security footage. The officer stopped the men in the hallway to take their photos in order to secure identification evidence. Now, in this, the guy's like, oh, well, why were they trying to take... The police already have a bevy of identifying photographs, but they don't have a picture of him in this particular distinctive jacket. Now, do they? Or maybe they do, but these guys don't know. They say, hey, these guys match. We're going to take a picture of them. We're going to find out. We're going to identify them. We're going to find out who they are. We've got a picture of them in the jacket. We're going to match the jacket up to the surveillance footage, the picture up to the surveillance footage, and then, by God, by golly, we've got it, boys. Plaintiff, who had, not is or was, or not is, excuse me, who had, past tense, represented, past tense, one of the men in unrelated proceedings, saw the photography underway and stepped between the officers and the suspects. Now, number one, have these suspects been arrested for this particular matter? No, they have not. So, have their Miranda rights to an attorney kicked in? Probably not. Now, if she was actively representing them on something, maybe. Maybe. And if she was, even then, maybe. But only for questioning. Remember, she can't physically interfere with the officer's investigation if it's taking pictures or drawing blood. In this case, they're taking pictures. And we all know public photography isn't a crime. So she says, stepped between the officers and the suspects. When one of the officers asked plaintiffs to step to one side in order to discuss the situation, she stood in place and said, we don't need any pictures taken, thank you. When informed that if she continued such conduct, she would be arrested, she responded, please do. Plaintiff was arrested without force and escorted in handcuffs to a holding cell in the basement of the courthouse. Appellant argues the police officers lacked probable cause to arrest her for delaying or obstructing the investigation. Although she was apparently acting in good faith, on this record here, there could be no serious question that that the police, number one, were lawfully conducting a criminal investigation, and number two, had probable cause to conclude that plaintiff interfered with it. Under California Penal Code 148A1, it is a misdemeanor to willfully resist, delay, obstruct any police officer in the discharge or attempt to discharge of any duty of his or her office or employment. Probable cause exists when, under the totality of the circumstances known to the arresting officers, a prudent person would have concluded there was a fair probability that the defendant had committed a crime. Plaintiff in this case refused to step aside. She refused to step aside. It wasn't questioning, it was refusing to step aside so the officers can take a picture. thus giving the officers probable cause to conclude that she was interfering with their lawful photographic investigation. The officers could also reasonably conclude that plaintiff's statements to them were intended to further her interference. There is thus no merit to her claim she was arrested on the basis of speech alone. And then they go on to talk about the other things, but it is affirmed. The summary judgment in favor of the city of San Francisco and the officers was affirmed. So your 5-year-old case, Earl, lacks merit. Moving on. Las Vegas attorney claims he was arrested for telling police not to talk, or telling client not to talk with the police. So in this right here, we can see some issues. It is the Las Vegas attorney claiming that he was arrested for telling the client not to talk with the police. What do the police say? You can listen to the full version of the attorney, Stephen Stubbs, who has a long and storied history of antagonism with the Las Vegas PD, and I'm not blaming him for that. He's a defense attorney, and great, you get him, buddy. So all of this whole article is Stephen Stubbs said, Stubbs said, Stubbs said, Stubbs said, Stubbs says, Stubbs said. The attorney says, Stubbs said, Stubbs said, Stubbs said, Stubbs said. I mean, get it? Do you get it? This is one side. You're seeing one side. The Las Vegas police confirmed the arrest, but couldn't provide additional details about the circumstances surrounding Stubbs' arrest. The citation given to the attorney says he was arrested for obstructing the officers who were trying to conduct a blood draw, going on to detail how officers asked him twice to leave so they could conduct their blood draw, as well as the hospital security guard who advised Stubbs to leave so the officers could conduct the blood draw, or presumably it would be hospital staff conducting the blood draw. Stubbs says the security guard said, so this would be hearsay, although Stubbs saying it, sure, it's fine, I guess. Statement by a party opponent. The security guard said he was asked to leave, but says he never heard the officers make the request. So that's a very confusing statement. I don't know why they didn't ask the security guard what the security guard said. But anyway, it appears to me to be the police thought he was interfering with the hospital, presumably, conducting a blood draw. Now, just for fun and games, Stubbs, like I said, has a long and storied history with the Las Vegas Metro Police Department. Under similar circumstances, he went to the scene of an accident for his client, Kevin Desmarius, a member of the Backers for Class Minister Group. I don't know why I read that in a French accent, or a terrible French accent. But he lost this one pretty hard. He appealed it, and he lost the appeal as well. So there you go. Those are fun reading. You don't have to read them if you don't want to. But the point is, if there was an issue, then yes, attorneys and judges would fix it if there was an issue. But there's not an issue, Earl. That's why you had to find a 5-year-old case and a year-plus-year-old case. The 5-year-old case was found to be without merit, and we'll see what this case comes out to. But if he was, in fact, obstructing the officers while they were trying to have the hospital staff conduct a blood draw, well, then he's going to be SOL again. Thanks for watching. Don't listen to Earl. He's a habitual liar who does terrible research. And have a great day.